Good morning, everybody. We're starting with our next session now. I would hand over the proceedings to Ms. Karishma Rastogi, Secretary and Compliance Officer, IPA ICMIA. Please take over. Thank you.
Thank you. Thank you, Anshika. So, for the session on IBC, I would request all of you to please be seated. For the next session, I request Mr. Jitesh John, Executive Director, IBBI, to please occupy the distinguished chair. Mr. Jitesh John, Executive Director, IBBI, is immediately before his joining, he was serving as Economic Advisor in Ministry of Power. Mr. Jitesh John is an Indian Economics Service Officer of 2001 batch. He has completed more than 22 years in Government of India in various capacities. He has experience of working in financial sector, energy sector, infrastructure sector, and small and medium enterprise sector. He has a postgraduate degree in economics. Now I request Mr. Raghav Maheshwari, Assistant General Manager IBBI, to please occupy the distinguished chair. Raghav Maheshwari is currently serving as Assistant General Manager at IBBI. He works in Corporate Insolvency Resolution Process Division. He has experience in conducting inspections and investigation related to the service providers, including insolvency professionals and registered valuers. Prior to his role, he was posted in Advocacy Division of the board. In addition to his CA qualification, he is also a certified forensic auditor and mediator. So before starting the session, I would request Advocate Tanya Baranwal and CA Vishnu Tulsayan ji to please come here to present the memento and Uttreya. Thank you. Now I would request CA Pratim Bayal sir and Ms. Manoranjani madam to please come over and present memento and Uttreya to Mr. Raghav Maheshwari. Thank you. So I would request Mr. Jitesh John sir to please proceed with the session. Thank you.
Distinguished dignitaries, all the participants of his conclave, a very good morning to all of you. It's my privilege to be here and present this topic on this recent amendments to the code and this application for the resolution insolvency provisional. So, as we all are aware, the code is in sort of force. All the provisions except those relating to few like the CIIRP, group insolvency, and the cross-border, they have been enforced. It's in vogue, and all the corresponding regulations have also been notified by the IBBI. So now the entire framework is in vogue. It's in force, and before I go into the details of the amendments, so I'll just, if Chairperson had sort of elaborated this in detail, why these amendments were necessitated were largely because of two factors, the delays which we have been seeing and the low recoveries that have been happening. So all the provisions of the code, the new amendments which have been brought in typically tries to address these two most important factors. And along with it, what we have done is that several provisions have been brought in, which empowers the RP specifically to carry out the process in a more effective and efficient manner. Whatever, the last 10 years, whatever we have seen, whatever have been hindering the smooth sort of, conduct of the process, we have tried to address that through these amendments as well. So first I'll we'll divide this presentation like my colleague Raghav is there. So I'll sort of start with the corporate insolvency resolution process. So I am not going in detail in all the amendments, as Sir had said, around 60 odd amendments. But I'll just take up one of the few of the major amendments which we feel will have a very significant impact in addressing the twin sort of problems which we were facing, that is delays and low realizations. So one very important sort of issue which the process was sort of being affected was the delay, because the process itself, you have done the process, everything is done, and we have seen that in many times the approval of the resolution plan, that is taking a lot of time. Like we have the typical case of JP infrastructure, where the plan I think was filed somewhere in 2019 and the final approval came in 2023. That just because there were some disputes with the creditors with respect to the final what the allocation, the distribution would be. And similarly, there were many cases where the approval, I mean, you have painstakingly completed the entire process, but then it's so frustrating that the approval from NCLT is taking so much of time. So one thing which we noticed was that the plan was completely all right. All the creditors were happy with the plan, that's the best plan you could have got. But there were problems related to the inter-se sort of distribution among the creditors. So that was taking up a lot of time in litigation. And to sort of address that issue, what we have done is, through the amendments, we have enabled the breaking up of this approval process into two parts. One, the bid can be sort of approved first. The SRA can take over the company and he can start the implementation of the resolution. Meanwhile, the distribution related matters can be separately addressed. And so that what will happen is that many a times we feel that the bid being given, quoted by the successful the PRAs are many times low, because they also factor in this thing, because they are bidding in 2019, but after 3 years they're getting it. So obviously, I mean, it's simple economics that they factor in that risk also into the bid, and as a result, the realizations are sort of typically low. So this is one major amendment which has been brought in. So what we want is the RPs to identify, like if any of these, if, in your cases, if you come across such a scenario, please call a meeting of the COC, get the approval of the COC for this bifurcation, and then apply to the adjudicating authority. So this is what we expect the RPs to do. Please make an assessment and make use of this provision if it is suitable for your case. The another issue which sort of again was hindering the process was many times what happens is that the assets are intermingled. Like for example, the typical cases where the land belongs to the promoter and the building or the factory on which it is constructed belongs to the CD. So then the resolution becomes very complicated. Like without the land, the building alone cannot be resolved, and no bidder would come forward. We had seen many live cases in this regard, especially in the real estate sector. So what this provision helps you is that in case if, in such a case where the land, there are two assets belong to two parties, one is the CD and the other promoter, with the approval of the creditor, you can bring in wherever that's in possession. Obviously, it has to be in possession of the creditor. In that case, you can bring it to the estate of the CD, and then it can be resolved together. So again, what we expect the RPs to do is, please see if such a, issue is hindering the conduct of your process, and in such case, obtain the creditor's consent and disclose in the IM, and then you can sort of resolve this. And we have also made enabling amendments in the other regulations, like in liquidation also, so that if you require cooperation of the RPs in the other process, whether it is the PG to CD process or the liquidation process, we have amended our regulations to provide for cooperation from those RPs. Then again, Sir had also mentioned in the beginning, like cooperation is one big issue. Like as you know, in our IBC, it's largely an adversarial process. No promoter would like to give up control of his company. For right from admission till resolution, they try everything to sort of sabotage the process, if I may say. So now what the code has done is that the scope of section 19 has been enhanced to include any person who is or has been a personnel or even engaged in contract for a service. So the scope of persons who have to provide cooperation, or the kind of persons who have to provide cooperation, that list has been expanded. And we have also introduced a Form AC through the regulation. So this would help you to have a proper record of the handing over and taking over. And moreover, we have also amended the regulation to provide that in the first meeting, even without you asking, the creditors are required to share all the relevant information with you, which will help you in building up the IM and in the conduct of the process. So here our expectation is that the IP should use the broadened scope and reach out to all the persons who have now been included in the expanded scope, and then formally seek their cooperation under the section 19, and use this form to record all the proper handing over and taking over. And also please bring to the attention of the creditors that they are bound to share all the relevant information with you, which is required for the conduct of the process. And again, NCLT now, the NCLT has powers to penalize, people who are violating the directions. And if there is any non-compliance, if any person is not cooperating, please bring it to the attention of the AA and make an application before AA to impose the relevant penalty for non-cooperation. So this again, we have seen that there are in many cases we have seen very complex companies come into. Companies come into the CRP which have very diverse kind of businesses. Like the company could have a cement plant, a textile unit, a power plant, these hotel. So these are very sort of varied and diverse kind of businesses, and there would be hardly any buyer in India who would be interested to buy all these kind of diverse businesses. Because again, in India, it's not that one group, there are many groups which buy such kind of diverse businesses. And as a result, what we have seen is that the bidder participation in very big cases have been very limited. We may think that, if it's a big company, very sort of with so many assets, there would be a lot of bidders who would be coming up to lap up the company, but that's not been the case. So what happens is that, what we found out is that it's better. It will be better. We'll get a better outcome if we, invite multiple plans for that company. So that what will happen is that if the company has a hotel apart from many other units, you bid out the hotel separately, and there will be many people in India who are in the hotel business who will be willing up to bid for that company. So what will happen is that you will have more bidders for the company and consequently a better realization for the asset. So again, please, the IPs, what we ask us, please inform all the PRAs that multiple plans can be submitted. Earlier, there was a regulation which was coming in the way that you had to first invite the plan for the company as a whole. But now we have amended that, and you can, in the first instance itself, invite separate plans from the separate units of the company. So please inform all PRAs, in case you are handling such assignments, please do that. Invite separate plans. And of course, at least one of them has to, provide for the sale of company as a going concern. This again, there has been a lot of litigation with regard to the clarity with respect to security interest and priority of government use, especially after the Rainbow judgment. So this code amendment has provided that clarity. So we expect that litigation on this account would greatly reduce and leading to faster processes. And so again, the IPs, please ensure that they scrutinize all the claims and ensure that the security is backed by agreement and not just by operation of law. Because earlier, many cases, just by mere operation of the law, they claim to be secured, but now it has been clarified. And please, that penalties and fines, they make sure that they fall in the category where the government dues are. Many times in the case of, EPFO and other such government agencies, there is a, that bifurcation need to be very judiciously done. whatever falls in the, the waterfall, the fines and the penalties will fall under government dues. It need not be, even if that, the rest of it may be the part out of the state or maybe in the employees' dues. But fines and penalties, please be clear, they are government dues, and please treat them accordingly. And restoration of CRP. So, we know that sometimes because of various technical reasons, whether if within the time you don't get a plan, or if the AA rejects the plan, the company goes into liquidation. So now the code provides that there is one more opportunity that is being given, that is for the restoration of the CARP. So this provision has been brought in. So in case in your assignments, if you feel that the company is going into liquidation on because of these technical grounds, please convene a COC meeting and see if the possibility of restoration can be explored. And if the CAC approves, then please approach the AA and on restoration, re-invite the plans. So this is basically one more opportunity that is given, because as we all know, in CRP, the resolution is around 32%, but when it comes to liquidation, it's hardly 4%. So that difference is very, huge. So we should try every opportunity to ensure that the company is resolved and it doesn't go into liquidation. So the code now provides an opportunity to do that. The other important provision is that we found that in many times the resolution plans provide for extinguishment of guarantees of the promoter. So that is unfair to a lot of other creditors. So by way of the code amendment, we have now clarified, or we have sort of brought in this provision that the guarantees cannot be extinguished through a resolution plan. That is the promoter's obligations. It has to be pursued separately through the PG to CD proceedings. It cannot bring that here. So the communicate to the PRAs that the plan cannot be used to extinguish the liability of the creditors, the debtors. The creditors have every right to pursue whatever they need to their claims are from the promoter. And also, please mention clearly in the RFRP that the guarantor's liabilities cannot be extinguished. This again one major amendment which we feel has the potential to reduce delays, because as we know, the delays, a large part of it is because of litigation, and many of it is vexatious litigation just to buy time or to prolong or to frustrate the process. So now NCLT has been given power. They can impose penalties for frivolous and vexatious proceedings. So if you feel that, there have been some parties have been, submitting RAs, filing RAs before the AA just to frustrate the process, please tell the NCLT to impose penalties as per this provision. So the entitlement of dissenting FCs, this again has been a sort of matter of litigation and also a serious matter because of this provision, many plans or many CDs were going to liquidation because everybody had a incentive to dissent. So earlier, the provision was that they will get the lower of the liquidation value or the plan value. So now it has been clarified that they will get the lower of the LV or earlier they were supposed to get the liquidation value, but many times in practice that was higher than the plan value because the plan used to be very less. So they were insisting on an higher amount, which cannot come out of anywhere simply because the plan was less than the liquidation value. So here we have clarified that the lower of it would be the entitlement. So we believe that this would again lead to lesser litigations and more resolutions compared to pushing the CD to liquidation. So the withdrawal of this again is a highly misused provision, the 12-way provision. Many times we feel that the promoter simply uses provision to frustrate the process and to delay the proceedings. So now we have brought in this amendment where there is a limited window for withdrawal. That is, the withdrawal can happen only after the COC is constituted and before the invitation of EOE. So only during this period the withdrawal can happen. Please don't allow any withdrawal before the constitution of the COC because you need 90% approval of COC for withdrawal. Also, please don't entertain any withdrawal application after the invitation of the EOE. So this has been a highly misused provision earlier. So now with these safeguards, we feel that this would lead to a better resolution outcome. So so I would now request my colleague Raghav to take over the liquidation and the other provisions, liquidation, PG2CD, and the CIIRP, which is yet to be notified, but it will soon come into force because the government has to sort of notify like who will be the eligible creditors and who will be the eligible debtors. So once that notification comes out, our regulations are ready. So the moment the government, central government makes that notification, we'll issue the CIIRP regulation. And the CIIRP regulation is going to be path-breaking because it is envisaged to be an out-of-court process where the delays on account of admission and all can be done away with. And there is real potential for the genuine, the business failures to be addressed through CIIRP because it will be a cooperative process rather than an adversarial process. So my colleague Raghav will touch upon that and other things in the later part of the presentation. Thank you.
Thank you, sir. A very good morning to all of you. So as sir said, in coming slides, we'll cover the amendments relating to other processes apart from CIRP. So the most important amendment in liquidation process is that we now have COC to supervise the conduct of the liquidation process. So before that we had SCC, but the advice of the SCC was not binding. So code now enables that COC will be constituted during the COC which worked during CIRP will continue during the liquidation process. And the regulations have been provided in detail that the prior approval of COC will be required for all major decisions. So most of you would have already constituted COC during the liquidation process, but in case you have not done it till now, convert all the SCCs to COC immediately and call meeting of COCs, and all the key decisions should be taken with the approval of COC from now onwards. Another important amendment is regarding the mode of sale of the assets. So there was a problem that there was a risk of asset being sold to ineligible people, particularly the related parties of the liquidator or of the CD, which would undermine the integrity of the whole process. So now the regulations provide that, so initially also 29A was applicable to liquidation, but now we have explicitly provided that no sale to any person who is ineligible under 29A. Apart from that, in case of private sale, it has been completely stopped that you cannot sell it to any related party. And even in case of auctions, if any related party has to buy the assets during liquidation, it can be done only with the prior approval of adjudicating authority. So, as liquidator, as IPs, you should screen all the bidders and buyers for 29A eligibility thoroughly. Identify all the related parties of the CD and of yourself. And in case any of the related party wishes to bid in the liquidation process, approach A for permission. Another key amendments are to reduce the delay at the admission stage, that now the record of default from IU would be considered as a sufficient evidence for proving debt and default. So in case of a Section 7 application, if there is a debt, if there is a record of default issued by IU, then no other thing has to be relied upon and NCLT has to admit the case based on that information itself. And in case of Section 9 and Section 10 applications, it was observed that once the admission happens, IRPs used to struggle with respect to lack of information regarding the company. So now we have said that a detailed set of information regarding the company has to be furnished along with such applications, so that IRP has at the initial stage, they have a good sort of information regarding the company to begin with the process. Another important issue was regarding taking approval from CCI. So presently, before the amendment, it was required that all the PRs has to go and take approval of CCI. Now it has been provided that only successful bidder will need the will need the approval from CCI when the plan is submitted to NCLT. Then the reporting requirements of liquidators has been rationalized. So now all the other reports like asset memorandum, sale report, COC minutes have been incorporated into the revised format of progress report. and you only have to file progress report on a quarterly basis. The fees of liquid has also been rationalized. The logic behind is that now no claims has to be invited at the liquidation stage. So the claims invited during the CIRP stage will be used during the liquidation process. The reporting requirement has been rationalized. COC is there to oversee the process. So taking into account all these factors, the fees for liquidators has been rationalized. Then, with respect to NRRAs, not readily realizable asset, there was a NCLT order which said that the crystallization is important to transfer the asset as part of NRRA, and that was shared by a lot of stakeholders as a feedback that it is creating a problem in assignment of such NRRAs. So that crystallization requirement has been rationalized. Now NRRAs can be assigned even if the underlying amount or the litigation has not crystallized. Then, in case of individual insolvency, the biggest change has been that the interim moratorium has been removed. So, there were concerns of the misuse of interim moratorium by the promoters or the guarantors. So, now the interim moratorium has been removed from Section 96 of the Act. One confusion which was there among many people that whether the ongoing process where interim moratorium is already applicable, whether that will continue or not. So, we hereby clarify that on all the processes, even which the applications which are filed before the amendment, the interim moratorium will no longer continue. Recently, one High Court order has also clarified the same thing that the Act will apply on all applications, irrespective of the timing of filing of application, whether it is filed before amendment or after amendments. So now there is nothing like interim moratorium, and you may advise the creditors to initiate or continue the recovery proceedings as per the amended Section 96. Another important change which has been done in Section 94-95 application is that along with applications, a comprehensive statement of assets will be required to be submitted. So this will help the IPs in preparing the reports under Section 99 and also in running the process and in assessment of repayment plans. So regarding voluntary liquidation process, earlier there was no mechanism for exit. So in case a process is started, the code did not provide that how in case you have to discontinue the process, there was no mechanism available. Now the code has introduced a mechanism for terminating the voluntary liquidation. As you all know that the voluntary liquidation commences out of court. So the exit mechanism is also proposed to be out of court, and the regulations now provide that it provides the contents of the resolution that has to be passed if the voluntary liquidation process has to be terminated. And then there is only reporting obligation on the liquidator, like they have to report to adjudicating authority, IBBI, and the concerned ROC. And a new Form J has been introduced regarding this termination. So it's a completely out of court process. If for any reason the voluntary liquidation has to be terminated, a resolution is to be passed covering all the elements given in regulations, and that has to be intimated to the concerned authorities. Then with respect to PPIRP, so the code initially required that the applicants has to furnish a declaration at the beginning of the process that regarding avoidance transactions. So one such feedback was that because of such requirement of avoidance transactions being to be furnished at the beginning of the process has contributed to lack of uptake of this process. So now that requirement has been rationalized. So code now provides that IBBI will specify the documents to be furnished, and IBBI wide regulations has removed the requirement of filing declarations regarding avoidance transactions at the beginning of the process. So the duty of IP still remains for the assessment of the avoidance transactions, but the declaration at the beginning of the process has been rationalized. So the next set of amendments is regarding CIIRP. So as Jitesh sir mentioned that there were concerns regarding delays at the admission stage. So a completely new framework has been envisaged under the code. It's called Creditor Initiated Insolvency Resolution Process. So it's largely an out of court process, and then again there was concerns that if it's out of court process it can be misused. So it is being designed that only specified financial creditors will be allowed to start the process to prevent the misuse. And who will be those specified financial creditors that the central government will notify in coming times. And So its admission will be out of court, but the remaining process, for example, the 29A applicability, the binding nature of resolution plan, the withdrawal threshold, all are similar to CIRP. So there are two major differences. First, the admission is largely out of court. Second, it's a sort of debtor in possession model. So RP will be there, but the existing management will continue to run the company. But RP will be there and he'll attend all the AGMs, he'll attend all the board of directors meetings, and he'll have a veto power over all the decisions of the existing management. So it's a mix of debtor in possession with appropriate checks and balances to ensure the due diligence and control of the creditors also. So the code provides under section 58A that the eligible financial creditors and the companies on which it will apply, that will be notified by the central government. So a brief overview of the process is that initially the eligible financial creditors. So just assume that, for example, the scheduled commercial banks are notified. So all the scheduled commercial banks who are eligible creditors, they first have to decide with the 51% approval that they have to start this process. Then they'll send a notice to the company that to make, and they'll give them 30 days time to make representation. And then based on the consideration of representation, again, if with the 51% approval they decides to continue with the process, they'll simply appoint an RP and ask him to make public announcement, and the process starts. So the date of public announcement will be the date of commencement of the process. So now all the delays at the admission stage will be bypassed through this process. Now the CD can object this initiation at the NCLT. But again, there was a risk कि वो procedural ground पे they will contest the they'll go for litigation. So now it says that they can contest on two grounds. First is substantive ground, that there was no debt or there was no default. Second, procedural ground. If as a promoter I go to NCLT and contest on procedural ground, NCLT will convert it into CIRP. So there is no incentive for me to go and contest on procedural grounds. I can only go and contest on substantive grounds, which will not be a problem if the banks are starting the process generally. So so these kind of factors which led to delay have been taken into account while designing the framework. Now in this case, the moratorium by default will not be applicable, but if the creditors feel that there should be a moratorium to prevent asset stripping, they can approach NCLT and ask for moratorium. And the moratorium will be applicable from the date that application is made. So they need not wait for the order कि हम apply करेंगे and then order आएगा और तब से moratorium start होगा. From the date of application itself, the moratorium will continue. In case the NCLT rejects the application, the moratorium will stop. But otherwise, it begins from the date of application itself. So as I said, the management of the company will be the debtor itself. They'll continue. The powers of board of directors will not be suspended. But RP will be there. RP will call for claims, prepare IAM, do the 29A due diligence. So all those duties will apply mutatis mutandis to CIRP also. Plus he'll attend all the meetings. And they'll have veto power. And this veto power should be exercised in consultation with the COC. So the process of plan approval is very similar to CIRP. The committee of creditors, if approves the plan, it will go to NCLT. If NCLT approves the plan, it will have same binding effect similar to CIRP. So it's a brief timeline overview that the process is designed to be completed in 150 days, and there's a provision for one-time extension of 45 days. Now one more important feature is there that at any stage, if the promoters or the CD does not cooperate, the COC, without giving any reason, can decide to convert the process into CIRP. So there is no incentive for the promoters to not cooperate. So basically, as Sir said, that if there are, so this process is basically designed to cater to cases where there is genuine business failure and the promoters or the business or the debtor wants to cooperate with the creditors to resolve a genuine business failure. So it's not a kind of adversarial process. It is envisaged to be a process where CD cooperates with the creditors. So apart from other grounds like where no plan is received or they are not cooperating, COC at any stage can decide to convert IIRP into CIRP. And if they convert, the process will continue from that stage onwards. So, for example, if the Form G was issued and it is converted into CIRP, so the process will continue from that stage onwards. Similar to CIRP, there is a withdrawal mechanism also. It will require 90% of the COC approval, and it is not allowed before the constitution of COC, and the withdrawal order's effect will be similar to CIRP. So basically, it's a new process. The admission is largely out of court, and it will be only available for specified set of companies and notified class of financial creditors. Management remains with CD, RP supervises and has a veto power. All safeguards like avoidance, Section 29, Section 30 minimum entitlement will be there. An approved plan will have same binding effect, same clean set effect as that of CIRP. So, as sir said, the government is considering notifying the details, and once this notification comes out, will come out with the detailed regulations, which will provide a detailed mechanism to govern each and every step of this process. Another important amendment is regarding group insolvency. So, again, this is an enabling provision. The code itself does not provide detailed rules. It has empowered MCA to prescribe the manner and conditions of group insolvency. So now there were two options available with us, like substantive consolidation and procedural coordination. So the code envisages procedural coordination only at this stage. So it will cover issues like common bench for group entities, common IP, combined committee for group, and coordination arrangement among the companies. So this will help a coordinated resolution of related party entities. Another important amendment which the code provides is regarding cross-border insolvency. So it enables the Ministry of Corporate Affairs to prescribe detailed rules regarding cross-border. So as you might be aware that there was a committee set up to prescribe detailed rules in this regard, and they have recommended that the cross-border insolvency would be designed on the lines of UNCITRAL model law on cross-border insolvency. It provides for access for foreign insolvency professionals to Indian cases and Indian IPs to foreign courts. So in case the company has some assets located outside India, it will help us recover, take control of that asset, get recognized in those jurisdictions and claw back the money from those jurisdictions. So it will provide for access, recognition, reliefs and cooperation among multiple jurisdictions. So this was all about the major amendments to the code, and we'll circulate this presentation with all the participants after the session. So you can refer it later also. And as sir mentioned that in case you have any questions, any doubts or any clarifications you need regarding the amendments, we would be happy to respond. Thank you.